This video explains a narrow but important discrepancy in the federal record in Harrington and Grant versus Nationwide Insurance in case number 124CV00247-DAE. The federal court did enter a judgment. The question is not whether the judgment exists. The question is what that judgment actually decided and what it did not decide. A sanction dismissal is not the same thing as a factual determination of the underlying insurance benefits, payment accounting, and designation of insurance proceeds. Document 185-AO-450. Document 185 is an AO-450 judgment in a civil action. The standard form contains a specific choice stating that the plaintiff recovers nothing and that the action is dismissed on the merits. On this copy, the selection is not checked. Instead, the judgment uses other disposition and expressly states that it is entered pursuant to the document of 184. It then identifies dismissal with prejudice under Federal Rule 37 and 41, together with express connection to motions to quash and sanction. The blank decision section. The form also asks how the action was decided. It provides choices to the jury trial, trial before the judge, or a decision by judge on a motion. Those decision method sections are blank on the docket 185. That does not make the judgment disappear, but it's important when someone later treats that one-page judgment as if it proves that the underlying insurance claim itself was tried, audited, and factually adjudicated. Document 184. Document 184 is Judge Ezra's signed order. It adopts the magistrate's judge recommendation, grant motions to quash and sanctions relief, dismiss the claims with prejudice under Rule 37 and 41, awards reasonable expenses, and directs the clerk to enter a judgment. The order terminated the federal litigation, but the order does not on its face contain an audit of the total loss proceeds. It does not trace each payment. It does not identify the destination of every dollar, and it does not set out findings determining who was entitled to each insurance payment. Mind you, Harrington and Grant had 6 different separate insurance claims. What Jonathan Cunningham said at June 12, 2025 state court hearing, Jonathan Cunningham told the court, Amy Meacham, that he had Judge Ezra's order. He described the nationwide claim as having been dismissed with prejudice and the basis of the sanctions. That language is important because it tracks the federal sanction disposition. The discrepancy arises is if that sanction dismissed, it is later treated as something broader, as though it established the underlying insurance entitlement, payment routing, ownership of proceeds, and complete claim accounting had actually been adjudicated. The money trail is a separate question. The insurance money trail is a separate factual issue. The nationwide payment history materials identify multiple payments and different payees. The records identify Siegel, McCambridge, Singer, Mahoney, Ltd., an Illinois trust account, and firm, Foreign Corporation, limited among payment receipts, and they also identify a separate payment to Harrington, Grant, and PHH Mortgage Services. Those records create accounting questions. They do not, standing alone, prove wrongdoing. The underlying payment ledger, wire confirmation endorsements, authorization, bank records, and any applicable trust account records are what would establish exactly what each payment landed, who controlled it, and authority existed for that payment. However, it has been withheld for years as Harrington has been attacked over attempts to get the audit trail, whereas the parties would designate themselves as parties and hold themselves out to purport to still be representatives of Nationwide Mutual Insurance. Why the distinction matters. A litigation ending sanction judgment can have serious legal consequences. But terminating a lawsuit is different from a judge hearing an insurance counting, trace the total loss proceeds, determining each payee's entitled, and making factual findings where the money went. Those are different questions. A court order should be described according to what it actually says. It should not be enlarged into factual findings that do not appear on the order itself. The investigation question. For an investigation, regulatory, or reviewing court, the comparison is straightforward. First, what the document 184 and 185 actually say. Second, what did attorneys and other parties later say those documents meant? Third, what do the original insurance payment ledger, wired records, trust account records show actually happened to those proceeds? Those three records should compare side by side. Accuracy note. One final accuracy point. It would be too strong to say that the federal judgment is a fake or non-existent merely because boxes on AO-450 form are blank. The record reflects a clerk-entered AO-450 judgment pursuant to Judge Ezra's signed sanction order. The stronger and more precise issue is whether that sanction judgment was later overstated or used as though it adjudicated the underlying insurance payment merits and money trail when the text itself does not show those findings. Follow the order, follow the later representations, and follow the money. The interesting part is that we had never met Attorney Patrick M. Kemp. We never knew that he was accessing our claim records through Nationwide Insurance. Why? Because our home was a total loss. We never hired Patrick Kemp, ever. We never even knew that he had already accessed these funds and deposited them into his trust account long before any lawsuit was filed.